Hello, LiveLaw viewers. Welcome to Courts Today. Let us dive into the important legal headlines of today. The Bombay High Court has upheld suspension of a PhD student from Tata Institute of Social Sciences who was accused of anti-national activities. Quashing a case against Kailash Kher for hurting religious feelings in a song, the Bombay High Court quoted AG Noorani that intolerance of orthodoxy is a bane of Indian society. The Bombay High Court has asked the DGP to consider a man's complaint about a cop and women lawyers running false rape cases racket. The Kerala High Court has allowed PP Divya to access documents filed in a plea for CBI probe into ADM Naveen Babu's death. And the Rajasthan High Court has granted relief to contractual employee who was given only 2 months maternity leave in the year 2008. I'm your host Urvashi Chauhan, bringing you the important legal updates of the day, quick, crisp and to the point. Watch till the end, and if you find this update valuable, please do not forget to like, share and subscribe to our channel. Starting with an update from the Bombay High Court, which has upheld the 2-year suspension of a PhD student Ramdas KS from Tata Institute of Social Sciences who was debarred for participating in a politically motivated protest against the BJP government and the national education policy under the banner of Progressive Students Forum, that is PSF TISS. A division bench of Justices A.S. Chandorkar and M.M. Satya ruled that Ramdas's participation in the Parliament March on 12th January 2024 gave the false impression that TISS endorsed the protest, which the institute claimed had brought disrepute to it. The court noted some key factors like Ramdas admitted to using TISS's name along with PSF in a protest poster. The protest pamphlet contained anti-government slogans like Save India, Reject BJP, which criticized the ruling party and its education policies, and that the TISS honor code prohibits students from tarnishing the institution's name in the public domain. The bench emphasized that while Ramdas had the right to express political views, he could not do so under TISS banner. The court also found that TISS had the right to consider his past conduct when deciding on disciplinary action. It noted that Ramdas had previously participated in protests, including an overnight demonstration outside the TISS director's bungalow, which disrupted the director's personal space. Though no action was taken against him earlier, TISS took serious note of his involvement in the Parliament March. The court ruled that the 2-year suspension was justified, stating that the punishment was not disproportionate. Ramdas's freedom of expression was not violated as his actions were against institutional rules, and since he was receiving financial aid from TISS, his conduct could impact the institute's decision on his scholarship. Observing that intolerance and dissent from the orthodoxy have been a bane of the Indian society for centuries, the Bombay High Court has quashed the criminal case initiated against Bollywood singer Kailash Kher, who was accused of hurting the religious sentiments of the Hindu community in his popular song Ba Bum Bum, a track on Lord Shiva. The case was filed in Ludhiana by Narinder Makkar under Section 295A of IPC, which deals with deliberate and malicious acts intended to outrage religious feelings. The complainant alleged that the music video of the song hurt religious sentiments of the Hindu community because it depicted scenes where boys and girls danced in clumsy clothes and were seen kissing. A division bench of Justices Bharati Dangre and Shyam Chandak ruled that there was no deliberate or malicious intent on Kher's part. The court noted that the lyrics of the song were in praise of Lord Shiva and did not contain anything offensive. That Kher was only the singer and not the producer or director of the music video, and the actions of background dancers could not be blamed on him. The judges emphasized that every action disliked by a group does not amount to outraging religious sentiments, and Section 295A of IPC applies only when there is intentional insult to religion. The court quoted AG Noorani stating that intolerance towards dissent has been a problem in the Indian society for centuries. The court clarified that malice means acting with ill will or deliberate intent to harm, which was not proven in this case. It also highlighted that freedom of speech and expression is a fundamental right, though subject to reasonable restrictions under Article 19(2) of the Constitution. Moving ahead, the Bombay High Court has directed Maharashtra Director General of Police to consider an inquiry into allegations of false rape cases being filed by a group of women lawyers in collusion with a police officer. A division bench of Justices Revati Moite Dere and Dr. Neela Gokhale noted that such false cases not only destroy the reputation of the accused men but also harm genuine rape victims. This particular case was brought before the court through a letter petition sent from jail by a senior management official of a motor vehicle company who has been imprisoned for over 30 months based on a rape allegation by a woman lawyer he claims is a serial complainant targeting professionals for extortion. The petitioner alleged that a group of women lawyers operating in multiple states first established relations with affluent men, demand money under the pretext of love, and later threaten prosecution under stringent rape laws. During the hearing, the petitioner's counsel pointed out that an assistant police inspector has played a key role in lodging these false cases at the behest of two women advocates in Navi Mumbai and Thane, adding that although most cases are either withdrawn or result in acquittals, the accused men suffer prolonged imprisonment. The petitioner here, who spent around 3 years in prison, stated that his life, future and career have been irreparably damaged by the stigma of being labelled a rape accused and an ex-prisoner. In view of these contentions, the judges directed the state DGP to take action against the named women lawyers and the API if warranted, and granted 8 weeks for the DGP to appoint an officer, conduct an inquiry and submit a report to the court. And now coming to an update on the case relating to ADM Naveen Babu's death. The Kerala High Court has directed the registry to provide certified copies of the writ petition, exhibits and other documents filed by Manjusha, wife of the deceased ADM Naveen Babu, to PP Divya, who is accused of abetting his suicide. Justice Kausar Edapagat passed this order in response to an application by Divya in the writ petition where Manjusha sought a CBI probe into her husband's death. The court relied on precedents to hold that Divya is entitled to access these documents despite not being a party to the writ petition. If you recall, Naveen Babu was found hanging in his official quarters on 15th October 2024. Divya, a CPIM member, was accused of humiliating him in public during his farewell function, allegedly driving him to suicide. Manjusha, his wife, has claimed a homicidal angle and sought a CBI probe, arguing that Divya's political influence could affect the SIT investigation. However, the High Court had dismissed the petition, stating that Manjusha's ties with the ruling party were not sufficient grounds for a CBI probe. Manjusha later filed a writ appeal, arguing that flaws in the SIT investigation were overlooked, but the High Court dismissed the appeal also, affirming that there was no valid reason to doubt the impartiality of the SIT probe. And lastly, the Rajasthan High Court has ruled that denying 180 days of maternity leave to contractual female employees while granting it to regular employees violates Article 14 and 21 of the Constitution. The court directed the state to pay additional salary with 9% interest per annum to a Grade 2 nurse who was granted only 2 months of maternity leave in 2008 instead of 6 months. Justice Anup Kumar Dhand observed that a mother is a mother regardless of her employment status, and that newborns of contractual workers have the same right to life, care and protection as those of regular employees. The court emphasized that maternity is an inalienable right, and restricting maternity leave based on employment type denies equal opportunity to women. The petitioner in this case was appointed as a nurse in 2003, gave birth in 2008 and applied for 6 months of maternity leave. However, she was granted only 2 months as per a 2007 circular issued by the Rajasthan Finance Department, which limited maternity leave for contractual employees. The petitioner argued that the amended Rule 103 of the Rajasthan Service Rules 1951 extended maternity leave to 180 days without distinguishing between regular and contractual employees. The court has now said that once Rule 103 was amended, the state could not have discriminated against contractual employees, making the 2-month restriction unconstitutional. It also cited Article 15(3) and Article 42 of the Constitution, emphasizing the state's duty to ensure health protection and job security for pregnant working women. While declaring the state's action as unconstitutional, the court held that if extended leave could not be granted due to the passage of time, the petitioner must be compensated with additional salary for the remaining period with 9% annual interest.